Hi, I'm Kent Berk at the Scottsdale, Arizona law firm of Berk and Moskowitz, where we handle real estate and many other types of disputes in Arizona. I'm going to explain today what happened in the Compass Bank versus Amberwood development case decided by the Arizona Court of Appeals. This case involved issues that arose in connection with a fair market value hearing after a trustee sale by the bank. The case did not involve any questions regarding Arizona's anti-deficiency statutes. In other words, the anti-deficiency statutes did not apply. What happened was Guarantee Bank made a $20 million loan to Amberwood Development. The loan was later amended and increased to $40 million. Later, Guarantee Bank became Compass Bank. After the borrower defaulted, Compass Bank held a trustee sale at which Compass Bank made a credit bid, as it was allowed to do, and then sought a deficiency judgment against the borrowers and guarantors of about $7 million. In the deficiency action, the borrowers requested a fair market value hearing. And a fair market value hearing is the method whereby the borrower and the guarantors are protected against an excessive deficiency judgment created by the lender making too low of a bid at the trustee's sale. In other words, it's to protect against too low of bids at the trustee's sale. So the borrower in a fair market value hearing is entitled to a credit against the total debt for the amount bid at the trustee's sale or the actual fair market value of the property as of the date of the trustee's sale, whichever amount is greater. So in this case, Amberwood Development requested a fair market value hearing saying that the bank bid too low at the trustee's sale. At the fair market value hearing, the trial court, established the fair market value and entered a deficiency judgment against the borrowers and guarantors for about $7 million. The borrowers argued that the trial court committed two, as well as other errors at the fair market value hearing. First, they argued that the court applied the wrong definition of fair market value. Under ARS Section 33-814, the court is required to use a specific definition of fair market value in arriving at the value of the property as of the date of the trustee's sale. The borrower argued that the court used the FDIC definition, which was different than the Arizona definition, such that the trial court's ruling should be set aside. The Court of Appeals disagreed and said that the two definitions were sufficiently similar. At least in that case, there was no prejudice to the borrower or the guarantors by using the FDIC definition. Secondly, the appraisers that testified at this fair market value hearing testified to the value of the property about 20 days before the trustee's sale, whereas the statute requires a determination of fair market value as of the date of the trustee's sale. So the borrowers objected on that basis as well. And again, the Court of Appeals disagreed and said that the value as of 20 days earlier was admissible, but that the trial court was entitled to give the appraiser's testimony what weight it felt was appropriate, given that their valuation was not as of the exact date specified in the statute. So the Court of Appeals upheld the trial court's rulings and finding of the fair market value, even though the court used a slightly different definition of fair market value and allowed appraisers to testify as of a date before, a valuation date before the trustee sale. Now, I recommend, though, that anyone that is pursuing a fair market value hearing or defending against a fair market value hearing should still use the definition of fair market value in the statute and should have the appraiser establish the value as of the precise date of the trustee's sale for two reasons. One, some of the Court of Appeals rulings were based upon its view that the trial court had discretion in connection with this fair market value hearing, and discretionary rulings are very difficult to overturn. And secondly, the Court of Appeals decision in this Compass Bank versus Amberwood development is an unpublished memorandum decision, which is not binding on other courts or future cases. If you have any questions, you can check our website, arizrealestatelaw.com, or give us a call. Thank you.